Hi, Keala Hill here, Digital Marketing Specialist at B is for Brand and Internet Marketing Graduate Student at Full Sail University. Today, I'm presenting my analysis of Priceline.com's Terms and Conditions, Section 1, A through F. I'm going to address 1, whether or not it is a valid contract, 2, if website users are bound to the terms and conditions or if they should have to click I agree, 3, whether or not Priceline can be sued and why or why not, along with 4, my recommendations as a digital marketer, not an attorney. I am not an attorney and I am not dispensing legal advice in this video. Priceline.com is part of Booking Holdings, self-described as world leader in online travel and related services. Through its website portal, Priceline.com, it offers discounted rates on travel, airfare, hotel, car rental, and cruises. It's located in Norwalk, Connecticut. I'm going to begin the analysis by defining whether or not Priceline's terms and conditions are a valid contract. Seth A. Drucker, a Michigan-based attorney specialized in e-commerce, wrote an article in 2014 called Online Terms and Conditions. Are they enforceable? Can they be changed? What should you look out for in your contractual relationships? In the article, Drucker says that courts generally enforce terms and conditions on websites. So yes, this is a valid contract. However, while terms and conditions are typically non-negotiable enforceable contracts, in the case of Priceline, this has proved false due to the company not following their terms and conditions. There's an ongoing class action lawsuit involving Chapman versus Priceline Group, Inc. Judge Chatagny recently denied Priceline's motion to dismiss a class action lawsuit due to violations with the Connecticut Unfair Trade Practices Act for the following: breach of contract, breach of the covenant of good faith and fair dealing, breach of express warranty, and unjust enrichment. We'll discuss more in the Chapman case later in this presentation. So, while the terms and conditions are a valid contract, it was decided by Judge Chatagny that the company's practice was not in accordance with the terms and conditions as they were written in 2015. The next point I want to cover is whether site users are bound to the terms and conditions if they should have to click that they agree. In the article by Drucker, he says that, I'm quoting here, an enforceable contract requires an offer, acceptance, consideration, and in some cases, a writing. According to the IT Digital Legal Companion book by G. Landy, it is explored whether terms and conditions should be click wrap, browse wrap, or both. Landy suggests click wrap. A click wrap is a pop-up that contains 1. Notification that changes have been made to the terms and conditions, 2. A link to the terms and conditions, and 3. An option for a user to agree to the terms and conditions by either clicking I agree or an agreement by continuing to use the website. This affords the user the opportunity to easily navigate to the terms and conditions, which notifies them that changes have been made. Priceline's current terms and conditions agreement are triggered when a user starts the purchase process through their site. It is located directly under the area a user would enter their credit card number and directly above the next required step to move forward in the payment process, which is the Confirm Your Reservation button. The agreement, as stated in this purchase form, is that by clicking the Confirm Your Reservation button, you are agreeing to accept the booking conditions, terms and conditions, and privacy policy. All are hyperlinked to their corresponding documents. So, if a user makes a purchase, this ensures they are actively opting into the agreements. This acts in accordance to Drucker's outline of what defines a contract as an offer, opportunity for consideration, and acceptance by clicking to place the order. To settle a dispute using the current terms and conditions, the first step is to seek arbitration. Arbitration is the first requirement according to Connecticut state law. As stated at the beginning of this presentation, Priceline is located in Connecticut, so in its terms and conditions, they claim jurisdiction there. An article by bpslawyers.com states that Connecticut law requires mandatory arbitration for civil actions with an expected judgment of less than $50,000, excluding legal interests and costs. This law was mandated in 1982 by Public Act 82-441. In addition, Priceline states this is the first choice with small claims court as an option upon signed agreement by the claimants and the third party, but one may not pursue a class action lawsuit. Of course, preventing a class action lawsuit would only be possible if the company is not in violation of their contract, as previously mentioned in the Chapman versus Priceline Group, Inc. In 2015, when Chapman first brought suit, Priceline's terms and conditions listed their best price guaranteed feature in it, which guaranteed the lowest price on everything booked. Since then, Priceline has updated their terms and conditions and carefully states multiple times in multiple ways that they cannot have a class action lawsuit brought against them. This begs the question, is it legal for a business to say that no one is allowed to file a class action lawsuit? In 2010, in the case of AT&T Mobility LLC versus Conception, the U.S. Supreme Court held that AT&T's contract, which protected them from class action lawsuits, would stand. Overall, this means that companies are within their rights to ban class action lawsuits against them. The judgment was alongside a 2005 ruling in Discover Bank versus Christopher Bohr, wherein it was decided in favor of Discover Bank that if a company has a mandatory arbitration clause in conjunction with a class action waiver within its contract, that disputes must be settled with individual arbitration. This is the case with Priceline's current terms and conditions post Chapman's class action lawsuit. Additionally, Priceline removed the best price guaranteed feature from their terms and conditions and instead have Section 1B under their disclaimer of warranties stating that they do not warrant or make any representations regarding suitability, availability, accuracy, reliability, completeness, or timeliness of any material of any kind contained within the site for any purpose, including software, products, services, information, text, and related graphics content. So I'm not sure what's warranted on the Priceline website. Given the findings in this analysis, I have some recommendations. The first is to edit some of the wording. In the Terms and Conditions introduction, paragraph 2 states that Priceline is able to update the terms and conditions without notification. In an article by Eric Goldman, a professor of law at Santa Clara's University of Law, he cites the Harris versus Blockbuster case, where it was ruled that Blockbuster's use of the same kind of language in their user agreement was considered illusory, because nothing could stop them from changing it at any time. Therefore, the whole contract was void. It stands to reason that a judge may find the wording we just covered in Section 1B for the disclaimer of warranties equally illusory. Another perk to doing this is that it will allow for a more consumer-friendly wording as opposed to creating a divide between Priceline and its customers. The second recommendation is to implement a click wrap notification as discussed earlier in this presentation. Adding the date of the latest edit to the terms and conditions lets consumers know if they've already read the latest version or if they should reread it. This assists in the first recommendation with the wording in paragraph 2. In the 2016 case of Singer versus Priceline, the judgment was in favor of Priceline to dismiss it as a class action lawsuit due to the terms and conditions on the website. But the court noted in passing that there was no requirement for a customer to click a hyperlink to the terms and conditions. While Priceline has implemented a click-through during the purchase process, I believe it would be wise to err on the side of caution and add a click wrap style notification because cyber law is continually changing. My last recommendation is to add a clause that addresses the FOSTA-SESTA bill. The acronym stands for the Fight Online Sex Trafficking Act and the Stop Enabling Sex Traffickers Act, and are an amendment to Section 230 of the Communications Decency Act. If you don't already know what Section 230 of the CDA is, the Communications Decency Act, it is what has provided websites and interactive computer service providers immunity from user-generated third-party content. The bill trumps the immunity provided for a website with user-generated content, which is knowingly assisting, supporting, or facilitating a sex trafficking violation. Because the language in the bill is so broadly written, many websites are taking preemptive action to avoid testing the bill. Craigslist removed its personal section, Reddit removed several subsections, and Facebook is censoring sex-related ads and events. Priceline could be liable for reviews or ads created by third parties that even hinted at promoting or facilitating prostitution. Prostitution is not defined within the bill. Once again, erring on the side of caution makes the most sense, and I recommend consulting with Priceline attorneys to revise the terms and conditions to address FOSTA-SESTA. That's all for today. Thank you for watching my presentation.